Busuafo na etie fo ni di kwan so me pa me ma obi bia akwa aba eba channel so me daily update TV. Abusia me pa that was an introductory video na ye kwhwe no, and in the introductory video no ye hu bra lawyer Atta on the client edu Boahene omukọ Supreme Court. Na omukọ Supreme Court na Supreme Court so decided on the case omomodi akọ Supreme Court. Na abusia me pa ye beka last week bibi esi wo court na that I mean the High Court. Na bra Atta court no last week asem na America no na me pacho o court no ni bufu ye ema or work out of your friends the court na say the trial judge na no di asem no or work out of that judge no na adinti na or yes ade na or site say judge na odi asem no or ye bias na onu no hu ni say that judge na da so na case ni so di asem na there is no way obedi asem na ama on any client no. Because any maybe anase niye bi a judge ni a display ni a show off no e say just say as or tilt towards abano and I said the age internet say judge ni that so tena asem no so dia there is no way justice I can justice or no client ni ebenya na ba sa no ye nyina ka say na Atta even if cry say your so-called claim now will make it say, and I say your claim, but your so-called claim, will claim now will make it say the judge in a bias. At least I also do obu Emma court no, do obu Emma judge because one for obu Emma judge na nature say one for obu Emma court no, of which I and also one for obu Emma Supreme Court no cry because Supreme Court na ebe I mean the CJ and ebe panel nkofo was some cases na CJ no. A panel kofa na say we you be say koneko this asem way na wakwa house ma work out of your adintira oh no I say onu no hu ni say oh yeah bias towards on any client ama because of asem we kra Ghana ha ye ka renowned lawyers na one of them okahopa lawyer Oliver Baka Vamao epi ba bonte me ka say this is the first time pa obi a lawyer etimi a work out of a judge Abraham citing for contempt. Again, into the Ghana General Legal Council, and to me, I'm friend. To so far, I'm punished any power. Ada Atta or Sinu Biana. Emma Kesi crab a case pa na ebusuan e course I mean etie for me patcho I course would be bribe. We made a reportage our channel no so non quite all call for say lawyer Atta was almost citing for contempt and I said the Ghana General Legal Council a friend na punishment will be on man because any quite so team working out of a judge sir. And so that was the case pa na utimu who say adia na say ne ya lawyer Atta the chair judge and wanya ade na ebusia ene fine as usual so or filing motion that is the apex court, that is the Supreme Court say Supreme Court omonsi sa trial judge na ote asem no so no na ebusia na omokoye sa unanimous sin ediesi pa unanimously all the judge I mean the judges omotena case ni na so wo makwahye sa edu Boahene motion na ode baaye no o say hia na ha adenti na obeka say judge na that is the head of the I mean of the Supreme Court no Justice Bafu Boni acting chief justice or no obi say koneko this asem we no o ka che nipa say nipa na bias even fine say nipa na bias nsema obeka na say nipa na bias kra na o reasons nti a wo de ba court ni the apex court ni say yenyina so na yensesa sa judge no e wo say eye reason like ade a obi abetima reason with you a obi fa no hu obeka say ampa judge ade a wo ye yi de one year fair to edu Boahene client no enti se sene nneema si ko the judge otena so na se okasa o yes an nneema ne dia ampa justice aye ka no wan hwa adu Boahene client no onya na Supreme Court na tena se etima sesa ana say wo metima prohibit sa judge ni so obetima to aso edi case no but where ya na say make us reason how they call you no enti sa wu mukura na ade a wo ye kra wanya ade adu Boahene even if say o kase judge no bias towards your client ade na on twa ma judge no endi asani wie ebusu aye nyina ye court aye nim de we sete se judge no enya ba court rise no obia sorry na se judge ni so di asani wie a obie nu ha owotumi so obe sorry before the judge e wo se judge no sorry na oko ansa na mo amaka no so mu nyina mo aide mo apie eno no kire the kind of respect and I say ye make us a respect ye wo ma ye judges no one dey we sete nti adu Boahene judge ne te ho odi asem wetimi a raise some objections via my judge no your friends make us a judge no etimi akwahye saa wayi na ana say wa boy agumen kan sa wa boss saa wo request now make here now then we should buafu ana say wo de ohuni say judge na bias nti wa sorry free court on. So that was it. Ebusuano no dey see and I me patcho because say nkoma ye di nti na yesa dia bemu no. So Supreme Court jina so ka say we reasons nti a wo dey ba say yes Supreme Court judges no yen nyina so na yen prohibit na yen sesa sa judge no me patcho emunye dukra emunye duk uni sa reasons ni nyina na ye enfa kwa mu kra enfa kwa kra enti adu Boahene ni motion of file was Supreme Court ni say omon prohibit that trial judge no me patcho Supreme Court at dismises sa adu Boahene motion no sisi ano sa trial judge na o say court na say edi asem no na busua makasa kakra yenko tie bra adu Boahene ono ankasa epie babo nti be kire kwa de ntia ono no etimi working out of the high court judge no before class Supreme Court no so this ruling eba nyakopon hire obibia na onye obibia kese ye beto ayen common so me do obibia.
The fact that an application like this is pending at the Supreme Court, it didn't warrant an adjournment in the matter, and so he dismissed that adjournment and then proceeded to call the prosecution's second witness, who is the Director of Finance at the National Signals Bureau, who was supposed to give her evidence in chief. Now, Martin, a bit of background to this. At the last adjourned date, the Director of Finance at the National Signals Bureau submitted some receipts during her evidence in chief. Now, these receipts had to do with the expenditure that Kwabena Boahene during his tenure as the National Signals Bureau Director expended, really. So, Atta objected to that list of transactions or receipts which was going to be tendered, in indication that they were prejudicial, and the fact that it has to do with the National Signals Bureau, it meant that it would affect the security of the country, for which reason he wanted those documents not to be turned into as evidence. And then the prosecution, then led by the Deputy Attorney General, who, by the way, today in court was absent, indicated that it is not in the place of a private citizen to indicate which documentation in court is prejudicial or will affect the security of the nation. That mandate or power lies in the bosom of the executive and, by extension, the government. And then the judge agreed with that. And so that objection was overruled. And then the matter continued. This is one of such instances that Lawyer Atta has been relying on, indicating that since the case began, there's a term that he likes to use. He says the judge is on an ambulance mode. He just wants the case to be expedited and moved on at the detriment of his clients without them necessarily making the case. And so he went to the Supreme Court to file an application to prohibit the justice or the judge to continue to hear this matter. He spoke to us after this. He was still not pleased about the entire thing. But Martin, even after this was done, because he walked out of the court premises, the accused persons, Kwabena Boahene and his spouse, Angela J. Boateng, they were still in court. And because the matter had been dismissed, and then the hearing was continuing, meaning that the second accused was going to continue with the testimony. The judge ordered the accused person, Boahene, to defend him, to call his lawyer back, or meant that you stand on his own as his own lawyer. Now, at that point, the court went on a brief recess, and when they came back, Boahene indicated that indeed he hadn't been able to establish contact with his lawyer, and pleaded with the court that he wouldn't be able to, as it were, defend himself or represent himself, and so prayed for leniency and an adjournment, to which the court obliged, and the justice or the judge gave the adjournment. And so the case has been adjourned to October 30, Martin, for the continuation of this matter.
Right, Lord, thank you for that update. Let's now listen to Atta, who is lawyer for the former Signals Bureau Director, Kwabna Boahene.
In the court since 9 o'clock, as scheduled by the judge, we didn't see the face of the Attorney General. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment, and that he is ready to continue the case. As to why the judge is in an ambulance route to continue the case and cannot wait for the Supreme Court for 1 week, the list matters to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And then, I leave him to do what he wants to do best. That's why I've left the court.
Are your clients not going to be?
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons. Because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there. Because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But Counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter, in which there is an old authority, the Supreme Court has departed from the authority, and the Supreme Court in 2020 is asserting that when there is a pending application for prohibition, and the lawyer tells the judge looking after the affairs of the case that, look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased. If you see the Supreme Court decision and you don't want to respect it, I can't force him to obey the Supreme Court, which is at the summit of the justice delivery system. But I think we will have a day in the Supreme Court.
Okay.
And so that is Atta, who is lawyer for the former National Signals Bureau Director there. And the news is that they walked out of court today because they were asking for an adjournment, specifically because they thought that new evidence that had been tendered in was not in favor of the case that they were defending. And so when the judge declined, they decided to walk out, leaving the suspect alone before the judge. And, the suspect said that he could not defend himself. So the judge asked that he call his lawyer to come in and defend him. He says he's tried several times. He could not reach his lawyer or his legal counsel. So based on that, the judge decided to adjourn the case. So we'll definitely update you as to when the case will be recalled and see how it plays out. This is still 3FM.
Abusuame pacha me do bibia say na yakotie the reasons ntia lawyer Atta na ono ne ka say the high court judge ne and I said the trial judge ne biased towards on the client no na said the maka no and omo court no unanimously the judge the justices and I said the judges of the Supreme Court no omu nyina wo ma kwash me ka say wo ma dismiss the application and I said the motion na lawyer Atta file e Supreme Court na or person the Supreme Court prohibited the trial judge from continuing sa case, you know. And you know, Supreme Court say there be lawyer Atta asema odia be emunyedu once am working you know ya adwena enye yi you know almost say there be lawyer Atta asema working obo enye so obo better asem you know ya adwena enye yi kra you know sa ko back na sa trial judge na wo ka say no or bias to your client, you know, on asem so no on tenas no on to asem so no ndi asem no. Now this time around no we don't know. Say lawyer Atta be nyina nipa but we know say judges in I know me a professional or more yes or me a professional you know. Or more sheda emfa say why you waiting na there be omanya nisa but nipa say the nipa sweetie enti say why ade we no abana so ka say judge no ensanye we ya o lawyer Atta nka na ye judge nka send nka wo be fa no na send nka wo be fa but anyway ni nyina ka your friends court process no ho so judge bi ya de na so wani nji ho a obetima file application as a motion was Supreme Court and that another higher court that is the Supreme Court now must start that trial judge you know and it was also the right and he exercised the right yes into the right and just that say okoye no Supreme Court for also say you know ya adwena enye enti ne sa akọ na sa judge na ansantena asem no na ondi asem no fa comment share comment section on me beje na ya kenkan ye do bibia say